Well, hello everyone, and welcome to Uncivil Law, where as always we learn through the misfortunes of others. I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court, and I hope you're just having the most fantastic day. We are here with yet another legal news roundup, all the legal news that you need to know of that's going in our crazy world of ours, so that you might be better legally informed. Very exciting as always. We begin today's legal news roundup with Chipotle doing a little bit of the child labor. Yes, your favorite Mexican restaurant may be engaged in a little bit of the child labor. Not the only fast food industry to be caught up in this recently. A McDonald's franchise also caught up in this recently, where they had I forget what it was, 13, 14-year-olds working the fryer, which is particularly dangerous. And Chipotle also has similar problems in DC and has agreed to pay more than $300,000 in damages in relation to the child labor. So let's learn a little bit more about how your guac comes at the price of the kids. Let's learn a little bit more about this. Chipotle has agreed to pay $322,000 to Washington, D.C.'s Attorney General's office in settlement of the child labor lawsuit. We employed the children's. They are too young. We employed them anyway. Our bad. The lawsuit was filed against the California-based burrito chain over hundreds of child labor allegations, including failure to abide by legal minimums placed in the number of hours minor employees may work. So depending on your state and depending on the details, people who are younger may be able to work, but typically can only do so at reduced hours and only during certain hours of the day. So it may not necessarily be completely illegal to employ the youngers, but you may be employing them too much because, they're supposed to be doing their studies and other things when they're young. So, yeah, you might have worked them too hard. Besides paying the settlement fee, Chipotle is required to implement a new comprehensive training and workplace compliance program to ensure this doesn't happen again. I'm already assured. I am already assured that there will be no more problems in Chipotle land. We applaud young people who take the initiative to work in addition to going to school, but the law limits the hours they can work to ensure that they're healthy, well-rested, and able to fulfill responsibilities as students and to their families, the DC Attorney General said in a statement. Our investigation examined whether Chipotle violated labor laws intended to protect our children, and today's outcome continues to the Office of the Attorney General's proven track record to enforce DC labor protections to the fullest extent for the law. Chipotle, for its part, has defended its labor policies, which, is a strange flex. Our policies are perfectly fine. Okay. Did you employ the children's or not? You just said you just settled it, but okay. But said in compliance with the settlement is implement an enhanced labor scheduling program across all of its restaurants to address any issues with labor law violations. We're committed to ensuring that our restaurants are in full compliance with applicable law and regulations, and we believe that hiring workers beginning at age 16, we can provide younger employees with valuable experiences and opportunity for advancement, the Chipotle said. Also, they're available, and they're warm bodies who can, serve the salsa on your burrito. This is not the first time Chipotle or other industries or other fast food people have been caught out in this. Last September, Chipotle had to agree to pay $7.75 million in child labor violations to the state of New Jersey for a similar issue. So whatever retraining they did as a result of that $7.7 million wasn't apparently pretty effective. So why would the training now be any more effective, one wonders? This was the result of a 2020 audit in Chipotle labor policies that found more than 30,000 violations, including instances of minors working past the 40-hour work week limits. In 2020, Chipotle reached yet a similar settlement again with the state of Massachusetts paying $2 million in that case. Again, I would assume that each of these settlements would include a proviso that, you not do it again, or at a bare minimum, you might be incentivized to not do it again anyway, because it's just inherently wrong. But Chipotle just can't seem to avoid violating the law, no matter how much training they get. They're apparently not very good at it. Other restaurants, of course, including McDonald's, have faced similar conundrums. Yeah, we've discussed that, where one franchisee, I think it was the 13-year-olds, was the 13-year-olds with the fryer, which, kind of dangerous, right? So it wasn't just a 13-year-old working. It was a 13-year-old working in a way that was particularly dangerous because, hot oils. So yeah, please stop, maybe doing that. That would be great. Hello, Legal Vice Raiders. Welcome to the Uncivil Law Morning Legal Roundup. Thank you very much for raiding this beautiful channel, and I am very happy that you're here. Thus, for the moment, that brings us to the end of this story about Chipotle, which for the third time in as many years has been caught out with the child laborers. They would like to employ the young people. They would like to employ them many hours of the day. They would like them to do all the jobs. Hey, free labor, why is no one tapping this valuable labor market? Chipotle said to themselves, oh yeah, it's supposed to be illegal. And they got caught out in Massachusetts, and they got caught out in New York, and now I've got caught out in DC. But this time, they've really pinky promised to never do it again. I feel assured. So yes, your guac may come with a side of child labor, and that for the moment brings us to the end of discussion of this case. Push the button. And good morning, everyone, and welcome once again to Uncivil Law. I hope you're having the most beautiful morning. Thank you again, Vice Raiders, for joining us on this brilliant day where we try to learn all the things that are happening in our crazy, crazy world. There's so much stupid happening, and we have, just trying to keep up with the stupid. Okay, let's learn a little bit more about some stupid. Just because I murdered my brand new baby daughter by literally tossing them in a trash can, it shouldn't prevent me from going to college news. A teen who, threw away their brand new baby child being born. She was in the hospital already, and she went to the toilet and she gave birth and she threw it away in the trash and, being charged with the murders. But you know what she thinks? She thinks she should be allowed to go to college because college is good for the learning. Maybe it will help her learning that, throwing away, living babies in the trash, not a good thing to do. Maybe that will help her in that education, and she would like to make sure that she goes to the colleges. So let's learn a little bit more about why she'd like to go to the college and why some people seem to have a problem with her going to the colleges. Let's learn a little bit more about this. Several thousand people have signed an online petition that aims to ban the New Mexico teenager from attending university because she's accused of the murder. She gave birth to a baby boy in a hospital bathroom. She's already in the hospital, mind you. She's literally inside the hospital, a place which, can help to attend to medical emergencies and help with, the childbirth. But she's like, I'll just do it in the hospital bathroom by myself and then throw away the child in the trash. Nobody will notice. They noticed. Alexi Tervillo, who is 19, is charged with murder in the first degree, child abuse, and tampering with evidence over the birth of her son, which was found in the trash dead by the general hospital staff. Yeah, the janitor couldn't help noticing there seemed to be a fetus inside the trash can. That's not where they're supposed to be. Last week, the judge amended a pre-trial order in the case on bail, which allows the defendant to physically attend classes at New Mexico State. So the judge over here looks at this situation, I don't see why a little bit of child murder should in any way prevent this girl from attending the classes in person in New Mexico. She should be allowed to go to campus, and she should be allowed to walk the campus corridors and go to classes, and she should be allowed to have fun and frivolity with all of her new class friends. I can't see any problem with this, says the judge in New Mexico. Apparently, the bail conditions get more and more generous with every passing moment. An early order by a different judge had used domestic violence frameworks to craft no contact orders between the woman and the deceased child's father, who attends the same school. So, they're just going to be classmates together, walking on campus together, but please don't talk to each other. The earlier order could have resulted in an inadvertent bail violation, her attorney successfully argued. So earlier it was like, how about stay 500 feet away from the father of the child? And the defense lawyers over here are like, well, hey, Your Honor, that's too harsh. Because if she has to stay 500 feet away, she won't be able to attend the classes in person at the same university the father is also attending at the same time. Maybe they'll pass each other in the hallway. Maybe they'll pass each other on the campus. That's not fair. She should be allowed to attend the campus that the father's attending. And the judge is like, yep, that sounds fine. So stay 500 feet away, except if it's on college property. What happens on college property stays on college property, apparently in New Mexico. A Change.org petition, however, not so happy with the judge's ruling. There seems to be some people who think, this order from the judge, perhaps not really a good thing. So there's a bunch of people who think, maybe the woman should be banned and also potentially kicked out of school. Maybe the murderer should not be allowed to be on the school. Fashioning itself as the voice of concerned citizens in New Mexico, the petition asks authority and educational institutions to take immediate action to prevent the woman from pursuing a career in nursing or social work or any field of education, because apparently one of the fields that this woman is particularly interested in studying is nursing. Or maybe the social work. Well, I suppose she does have a unique perspective when it comes to social work issues. So maybe she is a particularly interesting voice. But some people think maybe the nursing and social work not suitable for the 19-year-old child murderer. Maybe not the best profession for her. The petition started on August 24th, has amassed 2,800 signatures a day and has about 14,000 signatures at the moment. The girl, however, is not currently attending classes. Defense attorney over here doing yeoman's work says the court allowed her to go to college, which she has the right to do. Some days it's difficult to be a defense attorney, people. Some days you have to get up there and you have to try to say with a straight face, yep, my client should totally be allowed to attend the college. Yep, because I'm, of course, a zealous advocate for my client's interest, and my client would like to attend the college. So, of course, my client should be allowed to attend the college. That would be a good thing for them to do, I say, as the zealous advocate for the child murderer. Some days it's difficult to be a defense attorney, people. The defense attorney continues by saying she's not on campus, she's currently taking classes via Zoom because of this case, and she doesn't want to create any controversies. Well, might be a little bit late for that, but whatever. The defense alleges the child was stillborn, which, all right. And also the girl is suing the hospital, which is just like the ultimate in chutzpah, right? How about I sue the hospital for wrongful death, which is the child stillborn or not, by the way, at this point, but okay. I'd like to sue the hospital for wrongful death on negligence. Okay, the lawsuit cites morphine that was administered to the girl after staff knew she was pregnant as the baby's cause of death. Wow. I mean, they say the best defense is a good offense. And she's like, I'm not guilty of the child murder. You're guilty of the child murder. I'm going to sue the hospital. Fun times and exciting. Prosecutors in the case alleged the boy was murdered, citing a medical examiner's report that classified the death as homicide based on presence of air in his lungs. The medical examiner over here thinks, I can't help noticing that the lungs seem to have inflated, which seems to suggest that the boy took a breath, which seems to somewhat undercut the idea of the stillborn. So the medical examiner less thrilled with the stillborn theory. The petitioners, for their part, argue the state's allegations alone are enough that the woman should not be granted access to professions of the entry on Mexico State University. Defense attorney, continuing to prove that defense attorney sometimes is a really difficult job, says, I don't pay much attention to social media. I find it pretty asinine and a way for people to spew hatred and malcontent. But when it comes to a danger to my client, I pay attention, so I've learned a little bit about the petition. Wow. I mean, this defense attorney is best defense attorney because they will help their client no matter what, man. They are here for their client and they will make sure that they are in your corner, no matter what. Hell or high water, baby. My client wants to attend classes. They're out on bail. I see no problem with that. Works for me. Yeah. There has been a reaction of disdain for the petition by the defense attorney, but caution about what the general tenor of the protest could mean for his clients. The defense attorney, continuing to do yeoman's work, says, "My fear is that when we get to jury selection, I may have some potential jurors who think like these close-minded people. It's not a question of whether I think my client is innocent. It's a question of whether I can get a fair trial." There might be some close-minded people out there who think that, throwing away even your stillborn baby, just throwing it away in the trash without a care in the world may be somewhat representative of poor character. So even if your client is telling the truth, which, the medical examiner somewhat disputes with, the evidence of breath inside the lungs, but even if your client was telling the truth, throwing away the stillborn baby just, in the garbage of the bathroom, well, there might be some closed-minded people out there who think that speaks somewhat poorly of our character. The petition, according to the defense lawyer, more or less convicts the defendant, saying that the woman has been someone who's been involved in such a heinous crime. Involved is one way to put it, and argues that allowing her to pursue an education is morally wrong. Well, I don't necessarily object to her pursuing an education. I would just prefer that it be done behind bars. So if she wants to do some correspondence school, like the rest of the prisoners, go nuts. Defense attorney, continuing to speak for his client, says, "These people just do not know the facts." And for some of these people, knowing the facts wouldn't assist them that much because their hatred and their closed-mindedness may not afford them the opportunity to learn. Okay. Apparently believing that disposing, newborn children, whether stillborn or otherwise, away in the trash, apparently that's a closed-minded, bigoted view. Okie dokie. You would think that if they're at a college or university, they're there to operate with an open mind and study and evaluate before reaching certain conclusions and making such malicious statements. Defense attorney over here thinks that, people should have an open mind. Have you reconsidered your position on the disposing of the stillborn child? Have you reconsidered your position on the child murder? Maybe it's not so bad. I mean, she's just 19. She's just, in a hospital, and she just gave birth, and, she just put it in the trash as one does. It's a perfectly normal thing to do. A perfectly normal, reasonable person. You're a reasonable person, aren't you? The reasonably prudent person. This is something the reasonably prudent person would do, right? Right? Yeah. The petitioners, for their part, apparently expressing their supposed closed-mindedness, have suggested 3 courses of action. First, the organizer of the petition would like the university, licensing boards, and relevant authorities to reconsider the admission to the university. The second ask is for stricter background checks and screening process to ensure the safety of the vulnerable. The third request is that administrators collaborate with local law enforcement agencies to ensure that individuals charged with violent crimes against children are not permitted to careers. Okay. Defense attorney over here suggests the petition was indicative of broader trends and can forward the impetus for violence in the future. Defense attorney saying, quote, "Sadly, some of these people react out of bias and ignorance." With all possible respect, defense attorney, I do have to admit to a little bit of bias in my heart. I do have a bit of bias against the child murderers, and even in the most favorable interpretation of facts, I'm somewhat opposed to the woman giving a stillborn birth and just be like, the trash can is perfectly fine. So if that's bias, my friend, then call me biased, I guessed. I could see how this could get dangerous in a hurry, with people going out and doing things so blatantly as without giving that any thought. You're worried that people might go out and do things blatantly without giving it thought. Really? Your concern as the defense attorney is that maybe people might go out and do things blatantly without giving it any thought. Defense attorney, who are we talking about at this point? Are we talking about the public at large or your own client who is accused of doing exactly that? Horrible things can result. It sure can. This mob mentality is extremely dangerous, and far too often in this country, in this day and age, what happens when people react like they are here? Defense attorney thinks that maybe your bigoted view that disposing the child in the trash can is wrong needs further consideration. Okay. There's very little I can say or do, defense attorney said. My job is to protect my client, ultimately try this case, and that's what I'm going to do. Well, you know, good for you, my friend. Good for you. You are supposed to protect your client. You are supposed to protect your client, but your client, unfortunately, has somewhat questionable character. Even under the most favorable interpretation of the story, perhaps not thinking in a way that a reasonably prudent person might think. But who am I to say? Maybe the reasonably prudent person gives birth to the stillborn child and thinks to themselves, the hospital bathroom trash is perfectly fine. That's something a reasonably prudent person would do. Maybe I'm wrong. Okay, let's wrap this up. Thus, that brings us to the end of the story about the 19-year-old woman who is accused of disposing of her brand new born baby in the hospital trash with the murder. She says, I didn't do the murder. She also says, I'd like to attend classes at the same university the baby's father is also attending at the same time, notwithstanding a no contact order. And the judge is like, yeah, that sounds fine to me. You know, that no contact order, we need a little red pen action. Okay, stay away 500 feet except on college campus. You know, that's totally cool. What is your problem? And defense attorney over here doing absolutely yeoman's work as a defense attorney says, you know, all of our views that says this is a problem or is bad is just bigotry and ignorance. And we are not being sufficiently open-minded, and we need to reconsider our stance on the issue of the disposing of the baby in the trash, I guess. So, yeah. So that case is ongoing, at least for the moment, brings us to the end of discussion of this story. Change the background, push the button. Fantastic. Good times. Good times. All right. Thank you, Bella Stella, for the 20 gift memberships. That is extremely appreciated. I do appreciate everyone who supports this channel in whatever way they can. Just a kind reminder that memberships to this channel are but a mere 99 cents a month. It's true. You can support at higher levels if you want, but the lowest membership level is 99 cents, which is literally the least YouTube will let me charge you. $1 every month. I'd buy that for $1 is what I'm hoping that you'll say. What do you get for your $1 a month? Well, you get your name in green. You get some cool little icon by your name that shows that you're a member, those little scales. That's kind of cool. You get access to some emojis for the membership, and you get access also to some member-only content, which typically is me doing gaming streams, for example. So when I do the gaming streams when I'm done, they become members only. And sometimes when I do a recording that goes badly, it's members only, right? Because it's like, oh, okay, you can watch my outtake, as it were, as members only. Plus, you get that warm feeling of satisfaction in your heart that you are an uncivilian and that other people that are not members are not uncivilians, and you therefore are better than them. You are better than them. You are an uncivilian. You are part of the cool in crew. They are part of the out crew, and you can, look at them with the disdain that is warranted. So all these benefits can come to you for a mere 99 cents. Plus, on a personal level, I get to eat, which is nice. So yeah, my income is substantially down from, when I was working full time, as one would anticipate. And so I kind of need the money. I'm not gonna lie, I kind of need the money. I keep having to cut my expenses down and down. It's like when I'm looking to moving again at Houston, I'm like, okay, let me see if I can get an apartment for even cheaper still, because I'm also thinking about not getting healthcare next year because I'm currently paying $400 a month on the exchange for the healthcare in exchange for I'm not even sure what. So I'm currently even contemplating abandoning my healthcare. I mean, that is $5,000 a year. So the $5,000 a year is good. And what happens if I have a heart attack, I guess? Well, then I'll have to crowdfund it, I suppose. So you guys can be my health insurance plan. Maybe we'll do that. Yeah. I mean, to be realistic, my healthcare plan is so piss poor that even if I did have healthcare, I'd still have to crowdfund it. So maybe it's the same either way. So yeah. Thank you, Eliane, for 5 gift memberships. Thank you, Henhouse Bath Company, for being a member for 11 months. Thank you, Sherry, for being a member for 4 months. Thank you, Graham A. Tome, for becoming a member for 99 cents. And thank you, Springstorm, for being a member for 4 months. All these things are good. Henhouse Bath Company says, am I still going to come to Nashville with Ricada? Yep, sure will. I will find myself a hostel or something, and I will slum it. But I will come. I will come. All right, let's do a new story. The issue lurker says, no, keep my insurance, but I'm telling you, the money is tight. So I have to look for ways to trim down. So I'm just looking at I'm doing what basically everyone does when money is tight and start looking at those expenses and be like, okay, what are my biggest single expenses? Oh, healthcare at $400 a month. Okay, that's a lot of expense, right? Maybe I shouldn't have that expense. So yeah, I'm basically doing what everyone does on a budget when they're kind of poor. So yeah, good times. Welcome to the realities of, all that stuff. All right. It's getting so bad I have to move to Canada. I wouldn't move to Canada. Canada is not free, man. That freedom of speech, yeah. Lower my cost by changing plans. I'm already on a very cheap plan. The healthcare is just inherently expensive. $400 a month for healthcare is unfortunately fairly low. There's not a lot less to go to. And when you get even less, then you get even less coverage. So you're like, what am I even buying for? I think the lowest plan I saw on the exchange was somewhere in the 300s. So there's not a lot less for me to go to. Just get a cheaper plan. I'm already on the cheapest plans. There's not a lot less cheaper to go to. Healthcare is just inherently expensive. This is as cheap as it gets. Sandy asks, what about getting a job? Well, this was supposed to be my job. And necessarily any job I get would reduce my ability to do this job. right? This is what I'm doing full time. So Sandy, sure. Could I get a full-time job? Sure. I don't know if I could stream anymore. I certainly would presumably, I'd be working presumably some sort of 9 to 5 or, maybe like even like 8 to 6 or something. So I wouldn't be able to stream trials anymore. I wouldn't be able to stream during the day. My streaming, I presumably would be able to maybe do some filming on Saturday or Sunday and then have edited stuff during the week. So it would just change the nature of the channel, or it would have to result in abandoning the channel. So what about getting a job? Yeah, maybe I get a job and that just dramatically impacts what I can do on the channel. But if the channel's not paying the bills, then maybe the channel needs to fall away. So maybe it's the end of the channel. So, okay, maybe it's just the end of the channel, or at least the channel in its current form. So yeah, okay, maybe. Post woke world asks, do I still practice law? No, I haven't. This has been full time for the last year. This job has been full time as a YouTuber. Has been full time, and maybe that's just not viable anymore. Maybe I need to go back doing something else. James, I'll kindly tell you not to tell me what to do. I'll do whatever the fuck I want. And if you have a problem with that, you can fuck right off. How about that? Don't tell me what to do. Fuck you. Editing, by the way, is a major pain in the ass. I'd just like to say it's very time consuming. All right, let's do a new story. For today's story, we take our attention to the Wisconsin Supreme Court, in which the Chief Justice, who is conservative, seems to be having some problems with the more left-leaning members of their associate justices. So there is a bit of an ideological split in the Wisconsin Supreme Court right now that's leading to all kinds of fun shenanigans, to the point where the Chief Justice of the Wisconsin Supreme Court has accused their fellow members of effectively staging a coup. So yeah, we got all kinds of interesting stuff going on here in Wisconsin. Let's learn a little bit more about this Cheese State massacre. The conservative Chief Justice of the Wisconsin Supreme Court on Monday told their liberal majority in a scathing email that they had staged a coup and conducted an illegal experiment when they voted to weaken her powers and fire the directors of the state courts. So she's like, wait a second, I'm supposed to be Chief Justice. That comes with the administrative roles. I was elected to this role. This is my job. And they're like, oh, nah, fam, we have enough votes to overrule you. So we have just voted to remove your powers. And we are also firing the directors of the state courts, even though that's kind of your job. So the Chief Justice over here, kind of pissed. Yep. The Chief Justice, in 2 emails obtained by the Associated Press, stated that firing and hiring a new state court director was illegal and ordering the interim state court director to stop signing orders without knowledge and approval. So who is the director of the state courts right now is apparently in disputes, because who has the power to hire and fire this person? So the Chief Justice is all over like, okay, this person who thinks that they're the court director, I don't think they're the court director, so there is a fun. The Chief Justice writing, you're making a mess of the judiciary, the court's an institution for years to come. This must stop. I have no confidence in the recent hostile takeover and chaotic effect this has on the court, staff, and overall stable functioning of the courts. Liberals, for their part, gained a 4-3 majority on the court when the Justice Perweskowitz began her 10-year term after winning election in April. Conservatives had held the majority for 15 years prior to that. So, the Wisconsin Supreme Court ideology flips from conservative to liberal, and the conservative Chief Justice says, you are using your new majority to undermine my role as Chief Justice and basically throw me out of office, even though I'm still within my term. In the first week of power, the liberal justices voted to fire the state court director, hire the news director, and create a committee to do much of the work that the Chief Justice had previously done. a move that significantly weakened the Chief Justice. She was elected by the conservative majority to a second two-year term as chief in May. So she was elected in May. There was another election in November. So for the next year and a half, there's a bit of a conflict. And so they're like, okay, my role is to do this administrative stuff. And the liberals' roles are like, nope, we're going to create a committee and take it outside the Chief Justice role. No, wait a second, that's my role. How fun. Justice Dillette, who's one of the four liberals, responded to the email by saying she was disappointed that the Chief Justice was communicating to the media with deeply inappropriate and at times partisan tone and tenure. The conflict is real. DeLay defended the actions of the majority of justice, saying everything they've done is constitutional, which how do you determine if something is constitutional, right? How do you determine if something's constitutional? Well, one of the ways you typically do that is by asking the Supreme Court. Oh, wait a second, we're the Supreme Court now. So it is constitutional because we say it is. Yep, that's usually how that goes. We're simply creating a process so that a majority of the court can effectively work in the face of intransigent and uncollegial chief who apparently insists on public debate about issues for political purpose rather than allowing the court majority to function as it always had, DeLay said. So no love lost between this associate justice and this chief justice. Fun times. On Monday, they sent an email saying the court director, an email telling them to stop signing orders under their name. Chief Justice writing to the court director saying, it's come to my attention that you've been signing my reserve judge orders without my knowledge and approval. You never asked for my permission. You do not have my permission. Stop. These orders are in my name. You have no lawful authority to sign them. If you sign anything else under my name, please advise immediately. It's going just that well in Wisconsin right now. Going just that well in Wisconsin right now, where the Chief Justice basically has to beg the court administrator to stop doing things. The court director, in their part, responded to the Chief Justice in another email obtained by the AP, saying that she vehemently disagrees the appointment was illegal. So the court director's all over here like, no, I don't respect your authority. She also defended her action signing orders assigning the reserve judges, saying state law gives her the authority. The chief administrator, writing to the chief judge, saying, I have legal authority and responsibility as well as moral obligations to sign authority. So it's going just that well. The Chief Justice, in their part, said in response to questions from the AP that in order not to create problems at the circuit court, she was reissuing the orders under her own name. The Chief Justice also said sending a cover letter saying that the court administrator would not allow staff to send. The Chief Justice said she would advertise nationally for a new director of the state courts, even as DeLay stood by the hiring of the court administrator. So apparently we're looking for a new director of the state courts. Maybe I should apply for that. That'd be good. The Chief Justice sent a scathing email to all the justices once again accusing the liberals of acting illegally, causing harm to the court's internal operations and public perception. The Chief Justice refused to schedule weekly meetings with what she called unconstitutionally invented committee created by the liberal justices. So there's some committee over here that they're like, oh, they're going to do the roles as Chief Justice. And like, no, they're not. I'm going to do the roles. Chief Justice writing, again, I will not condone the lawless destruction of the Constitution, the judiciary, or the courts. This is nothing short of an unprecedented coup. For 40 years, the role of Chief Justice has been understood and respected. Your short-term goals will cause long-term, irreparable damage to the judiciary. What a historical disgrace. The popcorn is real in Wisconsin. Get your butter, my friend, and butter that popcorn because it is super duper real. The Associate Justice DeLay, for their part, responded to the email by saying it was the Chief Justice, Ziegler, not the majority of justices who's to blame. Let it be crystal clear, Associate Justice DeLay said. The attempt to obstruct the proper business of the court and furtherance of justice comes from you. How exciting. The attempt to obstruct the proper business of the court and the furtherance of justice comes from you. How very, very exciting. Thus, that brings us to the end of this case dealing with the Wisconsin Supreme Court, which seems to be in a state of upheaval, as there is apparently a fight between the Chief Justice and the Associate Justices. The Chief Justice saying that the liberal justices have improperly circumvented the role of Chief Justice, appointed a committee to do the things the Chief Justice is supposed to do, and even gone so far as to appoint an administrator who is signing orders in the name of the Chief Justice that she hasn't authorized. So all kinds of fun things happening over here in Wisconsin, at least for the moment. That brings us to the end of discussion of this story. Push the button, change the background, fun times. Great. What's next? Thank you, Slacker, for becoming a $5.99 uncivilian. It is appreciated. Thank you very, very much. We do appreciate everyone who joins the channel. All right, what else we got today? You got to admit that's a pretty fire story. All right. All right, let's do one more. Excuse me. In true crime news and trial to potentially watch, a couple is on trial for a developmentally disabled teen's death in a hot car. So we've heard about these kinds of things before from time to time. One of those like horrific nightmares by a parent. And that happens somewhat disturbingly frequently, unfortunately. A parent leaves a child, usually it's a young child, usually it's a baby or a toddler, leaves them in the child seat of the back car, thinking that they've already dropped them off somewhere, and then leaves them in the car and the child actually cooks to death. It's horrific. And then the question, of course, about what charges, if any, should we bring against the parents who are responsible for this? What kind of charges, if any, are accountable for this? Well, this case is a spin on this because the child in question wasn't an infant or a toddler. The child in question was 13, but developmentally disabled. So there is an accusation that leaving the child in the backseat was not an accident, but actually was a deliberate attempt to murder the child because they were developmentally disabled. So what is the truth of this situation? Was the child accidentally left in the back seat? Was it murder? Was it murder because we were tired of dealing with the developmental disability of the teen? Let's learn a little bit more about this South Carolina trial in progress. A South Carolina couple is on trial for allegedly leaving the woman's developmentally disabled daughter to die in the hot temperatures of South Carolina summers, which, growing up in South Carolina myself, I can testify can get quite warm. Those South Carolina summers can get quite hot. In fact, one time, at least one time I remember I had heat stroke from being outside just in the summer heat. Fortunately, I got better, and I didn't really realize what had happened till after the fact. I didn't really realize what happened after the fact, but yeah, I got so warm that basically I had a heat stroke. So it can get quite warm. The victim in this case is a 13-year-old. This victim is nonverbal and wheelchair bound. So they were not physically able to get out of the car. So that is sort of the difference here, right? This is not an infant. This is not a newborn. This is not a young child, as is more typical in these kinds of cases. This is a 13-year-old. But they are nonverbal and wheelchair bound and left in the back of the seat. So accident or murder. The people being charged with this are Rita Pangolin, who is a teacher for a local school district, and Larry King. They're both charged with murder, unlawful conduct towards a child, and criminal conspiracy. The incident happened at King's home about 10 miles outside the city of Walterboro on August the 5th of 2019. That day featured highs in the upper 80s, and anyone who knows anything about a car knows it can get quite warm inside a car. So it might be upper 80s outside, but inside the car, gonna be kind of warm. The defendant allegedly claimed she had briefly stopped in the residence to grab a pack of cigarettes and left her daughter in the car. So she's like, okay, I just left the child in the car for a brief time. According to authorities, she claimed to return to find the child and the car keys locked inside. It was too late to save the young child by the time the defendant and King got spare keys to unlock the vehicle. So she's saying that she left the child in the car to get cigarettes, came back, the keys were locked in the car, and they then went to find a spare key, but it was too late. Why rock meets window, wasn't the plan in that situation, I don't know. Because, rock meets window is probably a better plan in that situation. First responders reportedly arrived to find the person out of the vehicle, but not breathing and beyond any help. Investigators say that the person was trapped there for 5 hours. 5 hours. So this wasn't just a brief stopover to get some cigarettes, at least according to the investigators. This wasn't just, okay, let me get into their house real quick. Let me get some cigarettes. Let me come right out. Oh my God, you died of the heat in such a small interval of time. No, apparently the investigators think 5 hours. That's a lot of time to pick up some cigarettes, one will notice. Temperatures in the Jeddah, they say, exceeded 130 degrees on the day in question because, yeah, it would. Contrary to the couple's story about the whole cigarettes thing, detectives claim to have found surveillance footage that showed the defendant putting the child into the vehicle at 11:15 a.m., shutting the door, and leaving them there. The couple was absent for an hour, briefly returned to check on the girl, then went back into the home, authorities say. So, not just a brief stopover. Not just a brief stopover. Okay, I'm just gonna jump in real quick to get some cigarettes. We come back an hour later. How you doing? You still okay? The nonverbal disabled child in the back, I guess, indicates somehow they're okay, I guess. You're like, yeah, you're fine. All right, back into the house, no problem. Then apparently, according to the surveillance footage, they allegedly did not step out for another 3 hours. And even when they did, they simply drove off in King's truck, leaving the child alone for another hour. We can't help noticing the surveillance footage somewhat seems to undercut your story, people. This wasn't just a brief stopover with some cigarettes. Oh my God, what a weird thing. No, you went inside for an hour to get your cigarettes, came back, oh, she's fine. Then 3 hours after that, you're like, okay, we're going to go off, but we're not even going to check on her. I'm sure she's still fine. 4 hours later. The couple then left the 13-year-old, they say, to die in the vehicle amid the summer temperatures. The defendant, for their part, resigned from the teaching later that month. Those who spoke to a local station who were only able to identify the teenager's loved ones says they don't think the South Carolina Department of Social Services acted appropriately in handling negligence complaints against the defendant, saying that there were 5 such complaints. So some people apparently were concerned that the defendant may not be acting completely properly with respect to their disabled child, maybe not handling it completely well. And we went 5 times Department of Social Services and say, hey, social services, can't help noticing that this couple seems to be not handling the child very well. You might want to look into it. And, they did it, and then the child died. So, yeah. Apparently, among other reports, was a report in March of 2019. School officials called DSS saying the mother brought the daughter to school with severe, untreated burn across her face, neck, and chest. Wow. Okay. You made the teachers the mandatory reporters and say, teachers, you must report. Okay. Hi, DSS? Yeah, hi, I'm a teacher. I'm a mandatory reporter. I'd like to tell you that one of my students came to class, couldn't help noticing severe severe untreated burns on the face, neck, and chest struck me as a little bit odd. Maybe you want to look into it. No, you don't. Everything is fine. Everything is awesome. Okay. The defendant, for their part, failed to take care of the injury, which ended up draining onto the child's shirt and emitting an odor, according to the lawsuit. Yeah, it was noticeable. There was some problems. The lawsuit, for their part, says that the agency failed to follow through. No, not my social services. Not my social services. This child seems to have severe burns. The burns are causing liquid to seep into their clothing. It kind of smells kind of bad. Like maybe it's infected or something. Might want to look into it. No? You're okay with all this? Okie dokie. Thus, that brings us to the story of Rita Pangalengan and Larry King, who might have murdered a 13-year-old child of the woman. Was it an accident or was it murder? Well, if it's an accident, it's the most foreseeable accident ever, which, we typically call like reckless when it's that foreseeable, right? Like if you knowingly, consciously disregard a substantial risk because there's a risk you're ignoring, that's what we typically call reckless. So reckless is about as good as it gets here. So is reckless the issue or was it murder with intent? So, okay, here's what happened. We took the child to the home to get cigarettes. We went inside to get our cigarettes. An hour later, we check on the child. Child seems fine to us, back inside the home. 3 hours later, so 4 hours into our journey, we're like, okay, we need to go out and get stuff. So they get into their truck to go get the things. Do they bother to check on the child? No, they don't. No, they don't. They just go out in their truck. I'm sure they're fine. They were fine 3 hours ago. I'm sure they're still fine inside the completely locked car. And then 5 hours later, oopsie doopsies, they're dead. So, was it a oopsie doopsies or was it a murder? Well, they're being tried for the murder. So that's how well it's going right now in South Carolina. Also, Child Services was warned 5 times that there was a problem, including with the untreated burns that were on the face and neck and all over the place. And Child Services over here like, no, this seems like a perfectly fit couple. They're a child. They're a wheelchair-bound child, by the way, a wheelchair-bound child who is nonverbal. But accidents happen when you're a kid. Yes, accidents happen when you're a kid. Burns when you're a kid, that could happen to anyone. It doesn't necessarily imply they're bad parents just because they're untreated burns on the child. That doesn't seem to suggest in any way that they're unfit. We don't see any problem here. And then the child died. So that's how well it's going in South Carolina, at least for the moment. That brings us to the end of discussion of this story. Change the background, push the button. Push the button. Push button. Yeah, there we go. All right, what else we got today? All right. Let's do Let's see what we got. Let's do this one. Okay. I think the new background is working. I think with the textured colored background is working and we flip between the different colors for different stories. I think that's kind of nice. I'm not sure if I'm necessarily thrilled with the layout. In sort of the layout of the thing, I'm just commenting on how it physically looks on the page, as it were. But I do like the background. I do like that, we changed the background for each story now. We got 12 different backgrounds, by the way, of this textured colored background. I kind of like the textured colored background. It's another way to visually distinguish it so you have a different background every time, which is kind of cool. And, I don't know if there's necessarily a better way to do things, because you could I think I like it though. It's not bad. And then you get the uncivil law sort of in the corner there of the camera, and then you get the logo on the bottom left. I think this is working. Is this working for you guys? I think it's working. And I set the background to be randomized, because of course I did. So every time we do a story, I just, click the button and it gives me a different random background between 1 and 12. Right? It doesn't particularly matter what color it is on any particular story. It just matters that they're different enough to break up the visual flow. So, there you go. All right, let's do this. In discrimination as it relates to child adoption news, a Tennessee adoption agency that is Christian in its nature is alleged to have discriminated against Jewish couples looking to adopt. So this gets into all kinds of fun freedom of religion news, right? So you have the freedom of religion to have a religion of your choice. And if you want to do the adoption and you want to do it on behalf of the government, that's going to come with rules, including potentially non-discrimination rules as it relates to the client. So if you want to be a Christian adoption agency, that's cool, but you have to, behave as the state would behave, which is to say you can't discriminate necessarily on the clients. So the appellate judges in Tennessee have taken a look at this and said, okay, there seems to be enough to go forward to say that this Christian adoption agency illegally discriminated against a Jewish couple because the Christian adoption agency was a state actor, because they were performing a state function, and therefore bound to not discriminate on the basis of religion. So let's learn a little bit more about this. State appellate judges in Tennessee have revived a couple lawsuit that alleges a state-sponsored Christian adoption agency wouldn't help them because of the Jewish religion, and argues that Tennessee law that protects such denials is unconstitutional. So that's what we've got going on, right? We've got a Christian adoption agency acting on behalf of the state. They're performing a state role. They're discriminating on the basis of religion is the allegation. And they say that this might be authorized by Tennessee law, but that itself is illegal. So let's learn a little bit about this. On Thursday, the 3-judge panel of the State Court of Appeals in Tennessee ruled that Elizabeth and Gabriel Rutin Ram have a right of taxpayers to sue in the case, as do 6 other taxpayer plaintiffs. The ruling overturned a lower court determination that none of them had standing, and now proceeds in trial court. So standing, of course, is always a problem when it comes to such things, when it comes to this issue. But there is an interesting issue when it comes to religious funding, when it comes to standing, because in that particular situation, just any random person can sue. It's one of the exceptions to standing. It's like there's exceptions upon exceptions upon exceptions. Welcome to law, right? So were these couples looking to adopt? Well, that might give them standing, but that doesn't seem to be the basis of it, right? That doesn't seem to be the basis of we were trying to adopt and they discriminated against us. They are simply saying that they're discriminating against people in general. It's like, okay, then you don't have standing. But wait a second. Is this religious funding? Is this funding of religion? In which case, yes, you do have standing. So taxpayer-based standing, right? Any random person has sufficient standing when it comes to the issue of funding of religion. The exceptions upon exceptions upon exceptions. The lawsuit against the state challenges a 2020 law that installed legal protections for private adoption agencies to reject state-funded placement of children to parents based on religious beliefs. So they say, there is a 2020 law that specifically authorizes this, but of course the law itself is unconstitutional, is the idea, because it discriminates on the basis of religion, freedom of religion, right? So the state law must necessarily bend. So let's learn more as we try to figure out what's going on. Much of the criticism of the law focused on how it shielded adoption agencies that refused to serve prospective LGBTQ plus minus sign, divided by sign, ampersand, upside down caret, squiggly mark parents. But the Rutten Rams allege that their discrimination is in the nature of religion, which of course has a special First Amendment and also state constitutional interest as it relates to freedom of religion. So yes, religion does get treated a little bit differently, as you would expect. In the lawsuit, the married couple says that the Holston United Methodist Home for Children in Greenerville barred them from taking Tennessee state-mandated foster parent training and denied them a home study certification when they attempted to adopt the child from Florida in 2021. So the child we want is Floridian. We'd like to adopt them in Tennessee. That apparently itself is fine. But in order to be a foster home in Tennessee, they have to take the Tennessee course, and they literally won't let them. So they can't adopt this child because, they won't let them take the course. The State Department of Child Services later provided the couple with the required training and home study, then approved them as foster parents. The couple has been fostering parent a teenage girl they hope to adopt. They'd like to foster at least one more child, for whom they'd likewise like to pursue adoption according to the ruling. The Americans Unite for Separation of Church and State, which is a civil rights advocacy group on this issue, filed a lawsuit on the couple's behalf, calling the week's ruling important, saying, quote, "This lovely couple wants to help a child in need, only to be told they can't get services from the taxpayer-funded agencies because they're the wrong religion. Liz and Gabe deserve their day in court, and Americans United intends to see they get what they deserve." A spokesperson for the Tennessee Attorney General said their office is reviewing the decision. A representative from Holston United Methodist Home for Children did not immediately return the email requesting comment. The home is not a defendant in this particular lawsuit. During the 2-1 ruling in 2022, the judges in the majority stated the plaintiff lacked legal standing to sue and did not rule on the constitutional protection. The judges, however, downplayed some of the lawsuit's arguments against the law, writing that it does not single out people of the Jewish faith as a disfavored, innately inferior group, which that is a little bit of a mischaracterization, right? So yes, the law didn't specifically say no Jewish people, but that isn't necessarily the problem. The problem isn't that the law said no Jewish people. The law has said you can discriminate on the basis of religion. So sure, it didn't hold out Jewish people for particular religious animus. It just held out all religious people for particular religious animus, and that's no good either. They also found the services the couple sought would not have been state-funded, they say, saying the scope of Houston's contract with the state is for services in the custody of the state of Tennessee. So they're over here like, okay, we're not a state actor. We're not a state actor with the adoption. And my sort of back of the envelope analysis and sort of the back of the head analysis is like, I think you're a state actor. You're performing a state function here, right? It's like, oh, we're not a state actor. We're simply like facilitating the adoption with the state. We're simply the middleman. We're not a state actor. You can't hold us responsible as an agent of the state. And I'm like, I hate to tell you this, but I think you're so integrated. I think that you're so integrated with state action. I think you're a state actor. I don't think we're just the middleman, don't blame us routine is going to work. Nice try and all, but no. Before the adoption law changed, some faith-based agencies had not allowed gay couples to adopt. The 2020 law provides legal protections to agencies that do so, which is, of course, a separate issue I will take note of, just, for the record. Can we discriminate against the gay couples is a separate issue from can we discriminate against the religious couples? Because freedom of religion has a specific constitutional guarantee. It's in the First Amendment. Look it up. And every state, to the best of my knowledge, and Tennessee apparently is no exception, has their own state level protections for the freedom of religion, because of course they do. So, you can't discriminate on the basis of religion, whatever might be said for gay or lesbian or whatever else, right? Freedom of religion is, in fact, an explicit constitutional guarantee. Other guarantees might be statutory in nature, right? If you're thinking about Civil Rights Act, for example, right? You're thinking about an act of Congress, for example, or a state level equivalent, right? Constitution, kind of more important than that. The Holston Conference of the United Methodist Church has said the Holston United Methodist Home for Children is a separate entity from the conference. So the Holston Conference of the group of all the churches is over here like, whoa, this part of this thing is not us. So they're like, what they're doing on their own time, and said they don't have any legal or financial responsibility. They're a wholly owned subsidiary, guys. They're not us, which I don't know if that's true or not, but it's just funny that, that they're trying to distance themselves from a member of their flock because they're like, well, we don't want any piece of this, right? So that's what's going on in Tennessee. Christopher Stapp in chat asked, there are private placement agencies as well. Where do you draw the line? Was the child or a state? See, I'm not sure you do draw the line. I'm not sure you do draw the line. That's in the nature of the thing, right? In the nature of the thing, right, is as long as we're talking about this in a systemic way, as long as we're talking about this in a sort of global way, the government can't do indirectly what it can't do directly, right? But my private actor, though, doesn't work. Right? So one of the classic examples I like, just to illustrate the point, is let's suppose the police cannot get a warrant for a particular property, okay? This is the premise. The police cannot get a warrant for a piece of property. They'd really like to, for whatever reasons they have. Whatever reasons they have, they'd really like to get a warrant, but they can't. So they say to themselves, I'm a clever police. I'm a clever police. What I'm going to do is I'm going to go hire a private investigator. Hey, private investigator, Dick Tracy, have you ever considered breaking into a piece of property and looking into it and looking and seeing if it has evidence? Hey, boy, have I. That sounds like a fun and exciting idea. I'd like to do that, says the private investigator, and then they do. The private investigator goes bust down the door or picks the lock or whatever, and it's like, I can't help noticing I found 1,000 kilos of cocaine in the house. All right, and so you bring your motion to suppress, and okay, they can't get a search warrant. There was no search warrant. And the police are all over here but it was private actor though. It wasn't us. It was the private investigator who made the decision to do it. And the courts are gonna look at you and be like, get the fuck out. Get bent, okay? No, you can't do that. You can't hire the private investigator and be like, oh, it's a private investigator, so it's not state action. It's state action, okay? You can't do that. So when you say, okay, they're private, when you say, oh, they're private placement agencies, I'm like, I'm not sure that there are, right? I'm not sure that there are private placement agencies because at that point, you are just acting as a state function. You are just a state actor, right? It's like, oh, we're completely independent. We're not state employees. We're completely independent. We're a private placement agency. And I'm over here as a court like, no, you're not. No, you're not. You're a state agency. Oh, we're totally private. We have nothing to do with the government. We just place the children for the adoption. And I'm over here like, no. So you ask me where's the line? And I'm like, what line? What line? Right? It's like, yeah, so that's the short answer to your question. Edwin asked, did Bush legalize sneak and peek? Sneak and peek isn't necessarily illegal even before Bush. Sneak and peek isn't necessarily illegal, right? A sneak, if you can do the search, right? If you can do the search, do you need to do the seizure? Right? That's sneak and peek is just search without the seizure, right? So if you have the right to do search and seizure, can you do search without seizure? One would imagine, right? I have the right to go look. I didn't do the seizure. I found the 1,000 pounds of drugs and didn't seize them. Why? Well, you can think of all possible, you can think of some reasons off the top of your head why the government might not seize the 1,000 pounds of cocaine they found in the guy's house. Use your creative muscle. Why might the police not seize the 1,000 pounds of cocaine? I'm sure you can think of some reasons if you put your thinking hat on. So is sneak and peek valid? Sure. To the extent you can get a valid search warrant, sure, why not? Why? It's just search without the seizure. Why wouldn't that be legal? That's fine. Yeah. Thus, that brings us to the end of this case for the moment about this Tennessee law issue with the private agency trying to do the adoption, but it looks suspiciously like state action. So it looks like you are performing a state role and a state function authorized by the state, and it's kind of state all the way down. So you may be a Christian church doing the adoption, but you're a state actor, at which point, you kind of have to obey the rules of any state actor. So not so much with the discrimination on the basis of religion. So this case will be allowed to proceed to figure out if that's what's actually going on, more development to follow, and at least for the moment, that brings us to the end of development of this story. Okay, the police selling it was not really one of the reasons I was hoping that you would develop. I was looking for legitimate reasons. The police might not seize it. The police are going to take it for themselves and sell it themselves was not really the answer I was looking for. I was looking for legal reasons that they might not do it. So I appreciate your answers, but they weren't quite what I was looking for. But maybe that's my fault for not asking the question properly. Why might the police not seize it? Yeah. All right, what else we got today? This probably won't make the edit, but we'll do one for me. It's fine. Change the background, push the button. In I Hate CLE 2 news, Maine has doubled down on suspension of an attorney who tried to get his assistant to attend CLEs because he hates them as much as I do. CLEs are continuing legal education. It are these things that lawyers have to do, and they are inevitably mind-numbingly and soul-suckingly boring. I recently played a little bit of a CLE on stream just to demonstrate how much they make you want to die inside. I think that they are purposefully crafted to try to mentally break you. It can only be the supposition. They're so universally bad. It must be part of some massive plot to break you down emotionally and logically, to mold you or something, or some other nefarious ends, because how could you design something this bad except for some deliberate malfeasance? But whatever the reasons behind the design of these CLEs being the way they are, you're unfortunately required to attend them, and you can't just have someone attend them on your behalf because, that doesn't work. Let's learn a little bit more about this. One of the most misleading feelings for young lawyers is the thought they're done with law classes now that you've earned your JD. If only. Even once you or your firm shell the thousands of dollars for that bar prep, you're done thinking your cap now and again every once in a while for CLEs, which I will object to that you put on your thinking cap. Because law school was kind of interesting, CLEs are not. CLEs are universally boring, dull, horrible experiences that make you want to die inside. So I don't put on my thinking cap so much as whatever cap it is that makes me try to have whatever bright hope it will have. I basically put on a flashlight in the hope that there will be enough light illuminating that I won't want to die inside. But whatever. Seems somewhat common knowledge, but your sentence refers to you, not one of your representatives. So when you have to do one of these things, it's you. A Maine lawyer didn't catch that part and tried to get his assistant to sit through CLEs and got suspended for a year. Yeah, I feel you, bro. The CLEs suck. They're horrible. I don't retain really any knowledge from them. It's like I attend a CLE and then I'm like, what did I just watch? Because it just basically goes one ear and out the other. They're completely ineffective for learning, right? You're listening to them and you're kind of paying attention. And then you get to the end and it's like, what just happened? So this guy got suspended. He fought the decision up to the highest court as he could, and went about just as well as it would expect. The Maine Supreme Judicial Court affirmed the 1-year suspension from the attorney who asked his assistant to take the continuing legal education classes instead of him. The sole practitioner, Donald Brown of Brewer, Maine, had appealed the order of Justice Thomas McKinnon of the Maine Superior Court, who found that Brown had violated the Maine rules of professional conduct and the Maine bar rules. According to the judge's finding, Brown became aware in late 2020 that he had to complete 12 hours of CLE. Brown signed up for 4 live seminars that require participants to acknowledge their presence when prompted, but Brown realized he had scheduling conflicts, so asked his assistant to sign on in his place. That's not great. Also, apparently he has other problems because the court also dinged him for representing a client in a divorce case after they had had a romantic liaison relationship, which could be a problem depending on timing, and also could be potentially a conflict of interest. So, or maybe it gives you particular motivation. I don't know. Maybe it helps represent your client ever better. But mixing relationships with the client can get a little bit tricky. Technically speaking, if you have a relationship pre-existing the nature of the professional engagement, it's technically ethical, but whatever. It might be Maine, but there's no way the dating pool is that small. For anyone else confused, paying attention to your client's personal matter is part of the job. Getting personal with them is not. Yeah, don't sleep with the client. You can sleep with them before they're the client, and you can sleep with them after the client, but don't sleep with them while they're the client, or don't sleep with them for the first time while they're the client, is more the point. This article writes that the best way to classify Brown's actions, legally speaking, is stupid. There's no doubt being a sole practitioner is hard. Whenever you get the chance to delegate something, you should, but this is one of those times you're not supposed to do that. Not to mention one of the times when it'd be really dumb to leave a paper trail. Some of the strongest evidence against him came in the view of text messages he sent to assistants. So apparently, he created a paper trail proving that this was happening. So traceability, wasn't really good. So maybe get your assistant to appear, but don't create a trail about it would be better off, I guess. Bush McFadden, how are you not a member of this stream? Bush, I feel disrespected at this point because, you're here so long. What do I have to do to earn your love? Damn. Thus, that brings us to the end of the story about the Maine attorney who tried to get his assistant to do the CLE, which sadly you cannot do. Well, although, to be honest, it's probably just about as effective as you attending it yourself in person, because they're so mind-numbingly, soul-crushingly boring that you're probably able to get just as much out of it with your assistant attending as you did. So I'm not sure what pragmatic difference it makes, but unfortunately, whatever the pragmatic realities of the crap that is CLE might be, you're nevertheless required to do it, no matter how much you hate it and it makes you want to die. So please don't have your assistant attend the CLE for you, and that for the moment brings the end of discussion of this story. Change the background, push the button. Great. All right. It's time for Florida Man. Florida Man. Florida Man. Florida Man is the best man of them all. Florida Man. Should we watch just a random CLE together to prove the point? No, I don't want to inflict on you. That's not fair. All right, let's read Florida Man. In Jean Valjean news, a Florida man has been arrested in a $1 million Uber Eats scam. Well, I would like to eat for free just as much as the next person, but apparently this guy took that to a whole new level by scamming Uber Eats out of $1 million. That is a lot of Uber Eats. Let's learn more about this story. Broward man from Florida has been arrested for allegedly scamming Uber Eats out of $1 million. $1 million. Traven Morgan, 21 years old, from Laurel Hill, Florida, is accused of orchestrating an organized scheme of fraud. His alleged accomplice, Roy Blackwood, 38, of Sunrise, Florida, also faces similar charges. Uber Eats, for its part, contacted the Broward Sheriff's Office in January after discovering some minor bookkeeping errors. It's alleged that Morgan created fake Uber Eats customer and delivery driver accounts, placing orders at designated Walgreens locations. While waiting nearby as a delivery driver, he would accept the order and received a prepaid credit from Uber to make the purchase. So I'm going to create all these fake accounts, fake driver accounts, fake customer accounts. I'm going to place an order while right next door to the store so that I'm in the position to accept it. And Walgreens and Uber gives me money to make the purchase. Instead of buying the item that he would order, however, Morgan would cancel the order and use the prepaid credit card to buy gifts cards from Walgreens, which is apparently something he was able to do. So he's able to cancel the order, but somehow keep the money that Uber Eats had gave him to buy the food. So he used the money to just buy, prepaid gift cards at the Walgreens that he was already sitting at. This scam apparently continued for some time. It started in November of 2020 and continued until November of that year, resulting in losses of approximately $500,000 for Uber. That is a lot of fronting of cash that Uber apparently is not very good at tracking. Authorities believe that Morgan and Blackwood, for their part, made about $10,000 themselves through the scheme. Morgan's fraudulent activities were brought to the attention of law enforcement when Uber reported that they committed additional crimes in Broward County. So the only way that Uber found out about this bookkeeping fraud was through other crimes. It wasn't even the crime that they were doing that got Uber's attention. It was something else. And then they're like, oh, the bookkeeping. Detectives followed Morgan and Blackwood as they drove to multiple Walgreens stores, accumulating over $5,000 in fraudulent charges in a single day. These guys are ambitious. Investigators were able to track Morgan's identity to multiple fake accounts with nearly 800 trips made in Florida. It's alleged that Morgan also used the stolen identities to create these accounts. On August 16th, Blackwood was arrested by Palm Beach Gardens police. On a Tuesday, Morgan was arrested in Tamarack by the Broward Sheriff's Office. How fun and exciting. Thank you, Boosh, for re-upping your membership. It is appreciated. I feel loved again. Thus, that brings us to the end of this story about Florida man arrested for an apparently $1 million Uber Eats scam. So all kinds of wonderful things. He apparently would get the money fronted to him by Uber Eats and then would just buy gift cards with it, cancel the order, and apparently was just allowed to keep the money Uber Eats fronted him to the tune of hundreds of thousands of dollars. Apparently he was able to do this. So it's going just that well for Florida man. And at least for the moment, that brings us to the end of discussion of this case. And that also brings us to the end of the stream. We had fun today, I think. You had fun. You had fun. You had fun. And I had fun. And all sorts of fun is good for everyone. Let's see who's streaming, if anybody, and who I can pay it forward. Because Vice is redirected to me. Who can I pay it forward to? Who is streaming? Let's see. Recovery Addict is streaming. And that's the only person who seems to be streaming right now. When is this Artie thing supposed to happen? It's scheduled for 6. I could send you to somewhere that won't be going live for like several hours. I guess I'll send you to Recovery Addict. He's covering the story in the South Carolina case that we covered together. Oh, Gibson, thank you. Thank you, Sandy. I always forget every time. That's why you're good to keep me on task. Make sure that I acknowledge the gifts. NIN Gal, 9 Inch Nail Gal, 1994, has been a member for 10 months. Thank you, 9 Inch Nail Gal, for being a member for 10 months. Bella Stella gifted 20 gift memberships. Elian gifted 5 gift memberships. Henhouse Bath Company gifted, or has been a member for 11 months rather. Sherry's been a member for 4 months. Grandma Tome hit that join button, as so many of you should. Hit that join button and make sure to join, and join to the 99-cent level. Springstorm has been a member for 4 months. Slacker hit that join button and decided not to join at the 99-cent level, but rather joining at the much more prestigious $5.99 level because he is just that much better than all of you. So you should make sure to be like Slacker and hit that join button and then select higher membership level. Sandy gifts 20 gift memberships. Rose gifts 10 gift memberships. And then Charlie Raven has been a member for 2 months. Boosh McFadden re-upped their membership to become a member for 6 months. Thank you very much. Bronca's live. I don't have Bronca on my redirect. Let's see. Yeah, Bronca doesn't show up as an option in my dropdown. So I'll send you over to Recovery Addict, who's covering the hot car case. Tell him I said hi. All right, so that's been all for now. Until later, my friends. I hope all's well. Cheers, my friends, and goodbye.